It's bigger than you. It's bigger than me. Bigger than you. It's bigger than all. It's bigger than me. Bigger than you. It's bigger than all. It's bigger than me. Bigger than you. It's bigger than all. It's bigger than me. Bigger than you.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Counsel wanted to see me at sidebar.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican police service lobby. Oh, for Trump's
Is
sake.
that correct?
Literally not true. I didn't ask you to interrupt me.
All right, good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. And I'm blurry. I don't have my goatee to focus on anymore. Good morning, everybody. Welcome. Come on in. I'm sorry I'm a little bit late. I had a couple things go on. First of all, we had the little venue last night where I needed to. I had to live stream my town's. It's like a pre-budget meeting. Is what it was, and it went longer than it was expected. Let's put it that way. It was longer than expected. So anyway, good times all around. Let's see. I don't know who's first. I'm guessing it's Greeners, but I don't know who is first in chat. Let me see. The news we have right here is this live stream is best. Right here, there it is. I was looking for somebody who had posted, who had it succinctly. There's no court today is running at the bottom of law and crime. Right. Unforeseeable circumstances, sick lawyer. They wouldn't be able to continue without one of the lawyers, just to guess. I think sick judge. I think Beverly has a slight cold, and between the stuffed nasal passages and the Bostonian accent, it would just be unbearable. It would be awful. So that's just my call. The Commonwealth is sick. Everyone's sick of the trial judge. Beverly's sick. Was it Greeners? It was Greeners. Greeners, congratulations, you won. This puts us behind schedule. I can't see how we can stay to our 8-week schedule if we're skipping days. And tomorrow, Beverly's going to be like, "I'm sorry, jurors, nobody wants to waste your time like that." But the nose. Greener says, "I confess." Congratulations, Greener's first in chat. What do we do now then? Pollen season is brutal here right now. Oh my goodness. It's crazy. We're mostly through our pollen season here. Now we're into snake season, which is almost as bad as pollen season, but in a different way. Linda Sturmer sentencing next Monday. Well, that's not on Memorial. When's Memorial Day? Help. When's Memorial? Is it in 2 weeks or a week? When is Memorial Day? Let me ask my brain. Hang on 1 second. When's Memorial Day? The 26th. 2 weeks. Okay, that's good. It's the 26th.
Memorial Day is on Monday, May 26th, 2025.
Hank Brennan's in court, so the Commonwealth isn't sick, says Kate. Let's see, what kind of noodle did you have? Spicy or non-spicy? I always do spicy. Spicy is the way to go. All right. 2 weeks from yesterday's Memorial Day. Okay, I think we're planning a slight trip over the long weekend. Is what we're a little getaway, just a weekend getaway. So we'll be back in time for work. All right. Good morning. Good morning. Well, with that said, we're going to change our. We have not been court hopping in ages. Oh my goodness. What do we do when we can't? It's been a while since we've hopped around and checked out some of the small courts that we like to visit when things are not going the way we thought. Let's see. No Karen Reed court today. No Karen Reed court today. Why? Trying to find the other ones. Everyone wants to know why. Well, we've got a few things to do before we get going. We obviously need to sing happy birthday to a couple people, and just like that, buffer goes off, but it wasn't with the birthdays. I thought it was. Amber, is this something I can report on? Okay, so now I'm curious. Now I'm wondering. It would be speculation, but I've got to ask: what happens if it wasn't somebody was sick? What happens if there's been a development of some sort? Sorry, as I'm doing this, I'm checking some of our small courts to see who's up and who's about right now. Let's do the birthday thing. Let's do the birthday thing, and we'll watch this because I think something may be developing. What are we watching instead? We're watching a couple things. We've got Middleton's live right now. We might jump there. Sarah, there's just all I can say is there's buzz right now that it's not somebody got sick. Like there's an energy in there that something's happening. There's a lot of anxiety, excitement, things like that. Which could, it could be anything. It could be anything really. Here's what it probably isn't. It probably isn't one of the, we've watched a couple trials where somebody called in a threat to the courthouse. It's probably not that, right? We would have known that because everyone would have been evacuated and there would have been a huge police response and everything. So you can rule that one out. I really doubt that the judge just woke up with a head cold and was like, I just can't today. I can't judge today. I'll judge another day. I don't think that's it. I went 10 minutes over yesterday. It was exhausting. No. That's funny. We have lots of speculation. Lots of speculation out there. Here's what we're going to do. I'm going to keep my ear to the ground, and we've got moderators and many viewers as well who are watching a couple good, trusted sources that are trying to dig on what's happening. And we're going to, as we find something out, we'll bring it to you. But as far as just speculation and rumors, that's all it is right now. That's all it is. The camera does not show in the courtroom. The camera's off. Cameras are off, and they've been pulled from the courtroom. So, all right. Do we have any birthdays today to celebrate before we get going? Let me change the thumbnail. Hang on. I think I need to make a. Let's see. I need to make a new picture for today, and it's going to have to be. I'm making a new thumbnail so people don't get confused. Alrighty, we're getting there. We're getting there. Sorry, you got to wait for it. This is worth it. This will be worth it. Is it May? It's gonna be May. It is May. Boom, boom. There it is. Delete that guy. Put this guy over here. And the date today is the 13th. It's the 13th thing. It's the unlucky day. Okay, download that. Okay, the thumbnail's just going to say that that it's a holiday today in the Karen Reed trial. All right. Development: Brian Higgins finally figured out what Karen was hinting at in her texts. There's some birthdays. We're going to celebrate these birthdays. Give me just a minute to get this pulled up on our live stream. Details, change the image to that one. Nope. No, not that one. That's a car. Change the image to this one. There we go. Save. Holiday today. Done. All right. Let's celebrate some birthdays. Let's get some birthday people sung to so they can begin their celebration. Everyone take a deep breath, stand up, shoulders back, project your voice to the back of the room, blend your voice with your neighbor. Warm up with me if you will. La 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 la. All right, here we go. We're going to celebrate Jerry Sides and Sarah celebrating a birthday today. Happy birthday to you. Happy birthday to you. Happy birthday, dear Jerry Sides and Sarah. Happy birthday to you. Jerry Sides and Sarah, happy birthday. I realize there are a million places you could be, a million people you could have celebrated with. But you chose to be here with us. Hang on, do we have another one? Happy birthday to you. Two more. Happy birthday to you. Happy birthday, just Kim and Valerie. Happy birthday to you. There we go. Two more people in. Happy birthday. I realize there are a million places you could be, a million people you could have celebrated with. You chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully you can turn some of that back to you and make your day a little more special, or begin by helping yourself to free pancakes at Denny's, IHOP, Waffle House, Village Inn, McDonald's, Tammy Dunlap's house, Andy's Grill, and Bob Evans. There we go. No Karen Reed trial. Just got notification. Yes, we're getting all sorts of updates on that. Haas Long is the RA Law Tube adjacent graduate program. Where does 16 months place me? Have a great day hanging out with me. It's 72 Fahrenheit. Whoa. It's freezing and raining here. It's freezing and rainy. Not freezing really, but it's like 60 degrees, which is cold. Sloth Life, congratulations. Attorney, 16 months. Thank you very much for your support. We're going to finish up with the birthday song. Listen for the drum cue so you can all join me with the drum solo on the big finish. Queen Olive Ruth Ann, welcome to the gallery. 28 months. Another OG. Here we go. All right, here we go. Big drum finish. All right, all right. Beautiful, beautiful. Good job, everybody. Yeah, we're hearing there might be a Zoom thing this afternoon. Like KK, it's supposed to be a Zoom at 11 a.m.
Happy birthday.
Yeah,
you look good.
Thank you, Judge Fleischer. Happy birthday to those who are celebrating. Michelle, this is the question of the day. We are trying to figure that out, and there's a lot of speculation. So if you just go on Twitter, people are going to say all sorts of things. We don't know what's true yet. Indy Cindy 01, hot pink courthouse in sight. 23 months. OG. Thank you, Indy Cindy. Next month you get it. That is awesome. Thank you for your support. How close are we? We're like 900 away to 65,000. We need like 900 people, and it's 900 subscribers. I wish it was members. 65,000 members would be unreal. Just yeah. But I wish it was subscriber. I mean, it's just subscribers. Zoom proceeding at 11 a.m. We're going to watch for that, see if we can get that feed if possible. Unavoidable circumstances. Maybe the feds were watching, says Hannah. Well, even if the feds were watching and decided that Yuri Buchanan said something that involved, was worthy of investigation or arrest or anything else, he's already off the stand. He's done. I don't know why that would put a stop to the trial. Yeah, we're not going to report on Diddy, that's for sure. How would the Zoom feed work with the jurors? I believe the jurors are gone, Jersey. That's my understanding. The jurors will not be there today, so no testimony today. Although there may be some proceedings, the lawyers might talk. Zoom could allow somebody who's for some reason not allowed to be here. It could be. Remember, we had in the Maya trial, wasn't it Greg who had a family member pass away in the middle of the trial? It could be something like that, where there's somebody's like, I can't be here, Your Honor. I need to be with my family right now. It could be an unavoidable circumstance like that. I feel this is a juror issue. They were not happy with Bev. Yuri needed the day after being destroyed by AJ. I've got mixed feelings on that, Britt. I do think that AJ scored some points with Yuri and pointed out some things where he really made him double down on Proctor and just be like, yeah, he's my guy. Go Proctor. And he forced him to do that, and it was a bad look for the Commonwealth. It was a bad look for Yuri. It also, I think he's instilled a little bit of doubt as to whether Yuri has been 100% truthful, just because he can't remember anything, and when he reads it, he doesn't recollect, and he doesn't want to say certain things. He's been withholding or begrudgingly giving out answers. I think he scored points there, but at the same time, I think the Commonwealth scored some points with some fairly solid testimony. If you believe Yuri Buchanan, and I realize that's the if, it's a predicate. If you believe Yuri Buchanan, Proctor did not have the opportunity or the time to go and drop off pieces of taillight at the scene before they were found. That's big for the Commonwealth. That's big. That would indicate that there was taillight there before the state troopers arrived and before the vehicle arrived at the Canton police station. All right, unavoidable circumstances. We're waiting to try to get more clarification on what the unavoidable circumstances are. I thought at the beginning of this trial that something big was going on this time. I really wouldn't be surprised that at some point this trial ends midway by a mistrial, or the state just calls it. Like, never mind. We're done. We're done. Could have given one of the pieces to the Alberts. Brian Higgins was there, right? He was the guy we watched on the security camera last night or yesterday. I saw online that people are saying, no, this wasn't Brian Higgins. That was Brian Albert dressed up like Brian Higgins. I'm not buying that. You guys, this is why. This is why I have a hard time with this is all a big conspiracy, and it began instantly as soon as the fight went down. The conspiracy kicked in, and everyone played their part. They were all drunk. That's why I have a hard time believing that they all just perfectly started making the phone calls they needed to instill an alibi, to place an alibi there, to get the records in place, that everything just fell into place, and everyone's like, ready, your parts, ready, go. I'm not buying that conspiracy. Now, I'm not saying there isn't a conspiracy. I say I'm not buying the conspiracy that everyone was involved. The Massachusetts state troopers were involved, and the Alberts and the Higgins and the McCabe and everybody was involved is a bit much for me. Now, there could be some bad nuts. There could be some bad apples in this mix that, with a little bit of steering, might have sent something the wrong way. And Proctor, yeah, we're looking at you. We're looking at you. We have some questions, right? But let's see. Can you zoom in on the hallway video where Brian's face can be seen? Yeah, we can do that. We have all the time in the world to look at video today. If I can find the right mouse. Okay. Alrighty. That's the car. Okay, we're going backwards. Ready? I'll let you get dizzy with me. How about that? Okay, we're going to go fast through this. I think it's backwards here. This is where he pulls in, gets out of the car, walks across, goes to the police station, comes in the police station. We look at the timestamp, and this is where you want it, right? What was the question? Can you zoom in on the hallway video where Brian's face can be seen? Okay, let's start right here. Let's do a little zoom. You guys can see this, right? I'll take your question off the screen, Genjo, if that's all right. Okay. There's a pretty good face shot. That's where they paused it. Okay, let's pause. Let me go back. See if it gets any clearer. It's got to be Higgins. It's got to be Higgins. Closed match at the waterfall. I do think someone said that the hoodie didn't fit him tightly. It looks like he's filling out that hoodie quite nicely, just like he did at the waterfall. It is the same hoodie. Some people have had some questions about the shoes. I think they're the same shoes. I'm not seeing it. I'm not seeing it be Albert. They also have Higgins keycard access data there. It's definitely Higgins. I agree. It's Higgins' body frame. Higgins said he went to the PD to move his personal vehicles. He has a couple cars there, right? He has a couple vehicles. So he drove his Jeep. He went there. He moved a car. And then he opened up a truck and took something out of the truck and brought it home. It looked like either a gun bag or a duffel bag of some sort. Look at the two different shoes. He came in with boots, changed his shoes. Let's see. He comes in with these white sneakers. Let's see what he wears when he goes out. Ready? Let's back up here. Backing up. I think it's the same sneakers. Still got those white sneakers with the black soles. I think it's the same. Oh, I didn't show you, did I? Sorry. I was watching. This is him leaving. He does this. He rolls his feet out to the outside. He takes a step and then sort of rolls his ankle out. It's a unique gait. I believe it is Higgins. Same shoes. Army Mom. No, it was Harley Davidson at the waterfall as well. All right. They look like Vans, not Nikes. Can you bring up a picture of Higgins? Possibly on 3. Let me try this. See if we can get. Let's see. Sorry, guys, trying to get this up on full screen so you can see it. We can jump back and forth. Court TV did a special on Higgins and Albert. Let's see. Let's see if we can figure out who is who. Okay, so here's Brian Albert right here. You see this? That's Brian Albert. And I'm going to bring back the face we have of him. Walking into the police station. I don't think this is the same. So we've got this guy and this guy. Now let's see if I can find another still shot of Brian Higgins to compare it to. There we go. Come on. There we go. Sorry. This just looks like him. The eyebrows, the nose, it just matches better. It's Higgins all the way. Definitely Higgins. Are we thinking the video of Higgins going from car to car, or what are we thinking it's telling us? I don't know. It seems weird that he went down to move the police cars, or his cars at the police station, but he also picked something up. Like he got something out of a duffel bag out of the side of a truck, which he did not move. He didn't move the truck. He just showed up and moved a car, and then he went over and grabbed something out of the truck, put it in his Jeep, and drove away. I'm curious what that was. It was funny when AJ referred to the guy as Higgins in the video during questioning, and then your mechanic referred to the person as either he or she. Yeah. Karen is sick? Oh, no. That's the bag he used for the trip to New York for a funeral. Is that like dress clothes or something? His travel bag. Let's see. Celio says, Yuri has just proved himself a professional liar to me. Should be honest about the facts and not evade the truth of the matter. We've heard an 11 o'clock Zoom, but the jurors have been sent home for the day. So we'll see if maybe they were told to come back, or looking at the docket. Nothing. Not seen anything. I don't know. I haven't been dragged before. Well, you haven't killed anyone either, but you're a homicide investigator, right? I know it's argumentative, but it's funny. It was funny. And because it was only allowed because he had sort of made that statement. He said, I wouldn't know because I haven't done it. And he's like, well, you also haven't killed people, but you investigate that. So it was good. Let's do a pinned coat. Can somebody put a post? I'll pin the best one. Doesn't matter who it is. Judge Canono. You're welcome. Good to have you here. Okay. Got a couple other documents. These are the three filings. Are these the filings that happened yesterday? Motion to preclude the impermissible hearsay under the guise of a Bowden defense. They took that one sidebar. Let me read this to you guys. This is a fun one. Okay. Let's see if we can get it on the screen. Why is my mouse not working? Oh, there we go. Has to be turned on, apparently. The mouse does not work when powered off. If you remember yesterday, the judge said when she walked into court, she said, I've got 3 motions sitting here on my desk, and I didn't have them when I checked my email this morning. She said, what's up with that? And Mr. Brennan talked a little bit about this one, which is the only one the court has addressed so far. But they did it at sidebar, so we don't know exactly what happened. And that is this right here, if you guys can see that. Nice. All right, let's do a quick read through and see what's happening here. This is the Commonwealth's motion, so it came from Brennan, to preclude, that means to keep out inadmissible hearsay. So keep out stuff that isn't allowed in, and hearsay under the guise of a Bowden defense. So they're saying that keep it out because it's hearsay, that's not admissible, even though the Commonwealth or the defense is saying that the Bowden defense allows us to bring this in. Evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated in circumstances in which it was reasonable to expect that the police should have conducted such tests, followed such procedures, or investigated such information is admissible. However, a defendant does not have an unfettered right to elicit evidence regarding the adequacy of the police investigation. The admissibility of such evidence hinges first and foremost on its relevance. Let's see, there's a case law where the judge exercised discretion to exclude third-party culprit evidence as part of the Bowden defense, where defense counsel's proffer did not demonstrate the probative weight of the Bowden evidence exceeded the risk of unfair prejudice. So that's his motion. Hang on, there's got to be more here. Go to continuous scroll. Is it skipping some? Yeah, it did. Okay, there we go. While Bowden preserves the defendant's right to attack the adequacy of the police investigation, that attack is still constrained by the rules of evidence. Nothing in the Bowden case authorizes a defendant to introduce otherwise inadmissible hearsay. The defense's attempt to elicit inadmissible hearsay under the guise of a Bowden defense is improper. The defense has failed to establish that certain information, particularly confidential materials provided by the United States Attorney's Office in February 2024, were known to Sergeant Yuri Buchanan, or that in these circumstances it would have been reasonable for police to investigate such information. For example, the federal government's decision to obtain cell phone records of an investigator and civilians does not... Whoa! They're talking about Proctor's phone? They're talking about Proctor's phone. The feds grabbed Proctor's phone. That's what I'm gathering from this. Does not fall within the parameters of Bowden, especially when there has never been a showing that those cell phone records were material and relevant to the investigation. Under Bowden, it must be reasonable to expect that police should have followed certain procedures or investigated such information to be admissible. Court has released a press release. Terrorized. We'll look at that in just a second. The questions repeatedly proffered by the defense are improper attempt to admit otherwise inadmissible evidence. Evidence admitted pursuant to a Bowden defense is not hearsay because it is not offered to show the truth of the matter asserted. Rather, that the information was provided to police is information that the testifying witness has personal knowledge of, and yet that information was not adequately investigated. Such evidence that police failed to investigate leads concerning another suspect must have been known to law enforcement at the time. Bowden does not permit the defendant to ask questions without proper foundation or questions that are replete of unauthenticated, inadmissible hearsay solely to infect the jury with speculative claims that the defense has continually failed to establish. More case law. Similarly, the defense intends to claim that police lost or destroyed evidence. The defense bears the initial burden to establish a reasonable possibility, based on concrete evidence rather than fertile imagination, that access to the evidence would have produced evidence favorable to his or her cause. If the defendant meets that burden, the trial judge must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. And we've got more case law. Given this defense strategy to ask repeated, improper, and argumentative questions, a curative instruction is insufficient. Therefore, the Commonwealth request of voir dire having the hearing of Sergeant Buchanan for this court to determine whether the areas of the defendant's proffer of Bowden's evidence is admissible before evidence and argument is made to the jury. We got that. The Commonwealth got their voir dire. And it was a voir dire hearing where AJ asked the questions to see if he had the knowledge of what happened, and he didn't remember anything. Thank you, Terrorized. I will look on Twitter for the X. So that was the first one. Okay. Mod chats are just updates. They're not things I'm saying in chat. Like Amber's doing work and access to Zoom and things like that. Here's what I can tell you about the access to Zoom. I can tell you what the court's answer is if we ask them if we can stream Zoom, and they'll say no unless you are on the approved list from the court. And the court has been very guarded in who they give the Zoom feed broadcast ability to. All right, next document. I believe this one has not yet been addressed by the judge or argued in court. And this one is the defendant's opposition to Commonwealth's motion to preclude that's the defense response. We know how this one ended up. Let me see if it gives us some clues on this one as to what they wanted to go into. Give us just a second here. I'm going to scan this one quickly. We oppose. They say it undermines Miss Reed's right to confront her accusers and examine witnesses. We should be able to ask cross-examination questions on any matter relevant to any issue in the case. There needs to be a reasonable good faith basis for doing so. Questions do not need to be based on admissible evidence, though they may be curtailed when a witness makes continual and repeated denials. He did, and it was curtailed. Talking about harassment. Testimony elicited in support of Ms. Reed's Bowden defense does not have the effect of harassing the witness or confusing the jury, nor are questions marginally relevant. It must have been his records that were pulled. That's interesting. The testimony Ms. Reed seeks to elicit in support of Bowden defense is inherently not hearsay and is admissible, says the defense. Defendants have the right to base their defense on the failure of police to adequately investigate a murder or to raise the issue of reasonable doubt as to the defendant's guilt in the minds of the jury. Regarding third-party culprits, whose existence was known to the police but whose potential involvement was never investigated. That would be Brian Higgins. Maybe his records were pulled some way by the feds. Sean White says, it appears the cancellation of today's testimony was a game-time decision. Prosecution team is here, and several people in the courthouse told me they just learned as well. Ted Daniels posted this. Thank you for the update, OG Sean White. Ted Daniels, one of the boots on the ground reporters there. What I bet is happening then at 11 o'clock is not going to be a big surprise. What is probably going to happen is the judge says, look, we lost a day of testimony, but let's get together and work through some of these issues that are outstanding. We've got some motions that are still hanging out there. We've got some things we could speed up if we take care of it today. That way we won't really lose a day if we can get that done. I bet that's what's going to happen. All right, evidence offered in support of Bowden defense is not hearsay testimony. That gets around the hearsay issue. Commonwealth's motion recognizes that questions about investigators' knowledge under Bowden defense are not hearsay. However, it proceeds to suggest the answers to questions to this effect are inadmissible hearsay. Wow. So they're drawing a thin line there. All right. The appropriate avenue for Commonwealth's concerns is a robust rebuttal. They didn't want the voir dire. Defense wanted to have a robust rebuttal instead, and the voir dire outside of the presence of the jury was the route that the judge went. So sided with the prosecution both in determining how to proceed and on the final ruling after the proceedings were done. So they lost that one. Last motion Let's see what this last one is here. This is another Commonwealth's motion. Okay, last motion that was made yesterday. This one also comes from the Commonwealth. Motion to introduce additional evidence of the nature of the defendant and the victim's relationship. Okay, so this is the Commonwealth wants to bring something else in beyond what they said they're going to bring in. This is going to be Aruba, I think. This has got to be Aruba. The Commonwealth, they went on vacation to Aruba, and there was a blow up between Karen and John. The Commonwealth moves to admit testimony through a percipient witness who observed the defendant and the victim's volatile and hostile relationship as it existed at the time of the victim's death. 4 weeks prior to the murder, the defendant became enraged at the victim for speaking to a female friend who was on their group vacation in Aruba and accused the victim of having an affair. This incident was observed by numerous individuals who will testify to their personal observations of the incident as well as to statements of the defendants in the immediate aftermath. Evidence of a defendant's prior bad acts may be admissible to prove opportunity, intent, preparation, plan, knowledge, pattern of operation, or common scheme, or use or course of conduct, as long as the probative value of the evidence is not outweighed by the risk of unfair prejudice. The determination to admit such evidence based on timeliness, place, character, or probative value is one for the trial judge to make, and it will be reversed on review only if palpably wrong. Evidence of the Aruba incident was proffered by the defendant through a series of text messages between the defendant and Brian Higgins, thus opening the door for the Commonwealth to rebut the defendant's misleading and inaccurate claims about what had occurred weeks prior in Aruba. This incident in Aruba seems to also be the turning point in the relationship, as the defendant told Brian Higgins that her relationship with the victim was a very, it's getting blurred here, very messed up situation. Wow. Says all the words. Right there. And she had observed the victim all over a friend's sister in the lobby of our hotel and accused the victim of having hooked up with another girl while in Aruba. In January 29th, 2022, voicemails previously entered into evidence. The defendant screams at the victim for apparently being with, I don't know these words. English was my first language, and some of these words are just completely new to me. Being with another girl, I think it says there, and repeatedly refers to the victim as a pervert. There's also been evidence that prior to arriving at 34 Fairview Road, there was reference to a woman the victim used to date. The defendant proffered the entirety of the text messages between herself and Brian Higgins, including the defendant's admissions about her feelings towards the victim and the nature of their relationship. The evidence proffered by the defendant also demonstrated a continuing animosity in the weeks and days prior to the victim's death. The jury should be permitted to hear from the witness of this Aruba incident, who will rebut the characterizations made by the defendant to Brian Higgins. Such testimony would be offered through Laura Sullivan, Marietta Sullivan, Aaron O'Keefe, and Juvenile KF. Evidence of a hostile relationship that tends to explain the purpose of a crime is irrelevant to the issue of malice or intent. This came in last time, didn't it? I seem to remember this came in last time. Maybe it was a for dire situation, a proffer, but I remember hearing it. In a domestic violence homicide, evidence of such prior disputes are relevant to show the volatile nature of the relationship between the defendant and the victim in the weeks and months preceding the murder, and to explain the defendant's intent and state of mind toward the victim. Domestic dispute at defendant's apartment before killing, evidence of it, including physical contact. Hey, how are you doing? Sorry, come on in. There's no court today. We don't know why.
Oh,
I think. Yeah, I think Karen Reed might be sick. State of mind toward the victim. Evidence of domestic dispute at defendant's apartment before killing, including physical contact, was relevant to show volatile nature of defendant's relationship with victim and defendant's intent. Evidence of these are case law, so that did not happen in this case specifically. They're saying everything that's in the parentheses right here, from this parenthesis all the way to this parenthesis, that is the explanation of the case law right here that's cited before. So here's the citation, and then the following bit from paren to paren is the explanation. So the next case law explanation says that this case law says the evidence of defendant's prior arrest for assault and battery of a victim, defendants and victims' restraining orders against each other, and pending divorce proceedings are admissible in homicide prosecution to show motive and hostile relationship. Another case law says evidence of defendant's previous threat to stab his girlfriend to death is admissible to show parties' violent relationship. Yeah, that seems like it. Another case law says allowing previous domestic violence incident by defendant against victim to be admitted in prosecution for subsequent domestic violence to show nature of relationship between the two and to show intent, motive, and absence of mistake of an accident. An absence of mistake or accident. So lots of case law exists to show prior bad acts in a relationship should be admitted in a homicide trial, which this is. Evidence that the defendant formed an attachment or another form for another may form the basis of an inference that the defendant entertained feelings of hostility towards the spouse prior to killing. Wow, that's quite a jump there. Because she pursued an outside relationship, it can be inferred, the basis of an inference. This is crazy. The basis of an inference that she felt hostility towards the spouse. Whew. There was no spouse in this case. It was boyfriend, girlfriend, so I don't think that would apply. Moreover, the state of mind exception to the hearsay rule calls for evidence of a murder victim's state of mind as proof of the defendant's motive to kill the victim when there was also evidence the defendant was aware of the state of mind at the time of the crime and would likely respond to it. Evidence of the defendant's prior conduct is permissible and highly probative to show the defendant's state of mind, to show the defendant's motive, to show the defendant's common pattern and behavior toward the victim, in particular, as demonstrated as by previously admitted evidence that the defendant would become enraged and accuse the victim of cheating on her, and the nature of the defendant and victim's relationship. Massachusetts courts have repeatedly admitted evidence of prior bad acts to demonstrate a hostile relationship between the defendant and the victim because this hostility is relevant to the defendant's motive to harm or kill the victim. More case law. A lot of case law saying this should come in. The Commonwealth is entitled to present a full picture of events as possible of the events surrounding the accident. So they say this adds to that picture. More case law saying they can. Where the defendant has opened the door, it is especially significant for the jury to understand that it was the defendant who repeatedly refused to accept the victim's desire to terminate their relationship. Where the defendant has opened the door. So the questioning by AJ as to who was leading, who was instigating the relationship, who cut it off, all that's got to be what the Commonwealth is saying as they opened the door. The defendant's, where the defendant has opened the door, it is especially significant for the jury to understand that it was the defendant who repeatedly refused to accept the victim's desire to, I think there's a typo in there, to terminate their relationship. The defendant, is this typo as well? Apostrophe S. Made repeated hostile accusations that the victim was having an affair and that there was an established pattern of hostility occurring in the weeks and days preceding the murder. For all above-mentioned reasons, prior misconduct and evidence of domestic violence should be admissible at trial. So this is Aruba, if it comes in. That's the justification for it. Let's see. Ms. John Hockey says, a member for 12. Congratulations on the year mark. That is awesome. Johnny Hockey, been here since 2023. Found you during Maya trial. I'm a full-time caregiver for my adopted daughter with disabilities. I'm occupied 24/7. Thank you for the welcome respite. Miss Johnny Hockey, welcome. Sounds like you're a lurker more than a talker, but we love that you're here, and thank you. Thank you for 12 months of support for the channel. That's huge. We're trying to dig more on the Zoom information on the Karen Reed trial that will have some sort of proceeding, even if it's outside of the jury's presence. Right now, we don't know. We might know no more at 11. I think the Aruba thing is nothing to really bring in. They brought it up on the calls and video, I believe, just bringing up the things already discussed. Where is he getting domestic violence from? Nothing like it. All the domestic violence that we were talking about, reading there in that paper, were citations of case law. There may be a couple reports of an angry fight by an observer and possibly by a juvenile. KF is what they said, if there was a fight that went on. Why are they having a meeting on Zoom instead of being in court? Possibly so because court was canceled, instead of keeping the lawyers around to sit there and wait for court to begin, they could go back and do some work that they need to do, and then just log in because the jury's not there. That's basically it. All right. While we do this, Josh has sent us a link. Before I go to Josh's link, I was going to jump to another court really quickly and just jump in and see what's up with Judge Middleton, who was live. Let's see. Is McBurney live as well? He's got a civil trial. Hang on. Judge McBurney has a civil trial of the Pope versus Marta. It's not the Pope, I think. It's just Pope. Let's see who else is going on. Yeah, let's go here to one of our old favorites, Judge Middleton, and then I'll get the other one lined up right now.
We have two cases this morning with Jody Lynette Wood, also known as Jody Lynette Klein. The felony case is in file 241559. And the original complaint alleges carrying concealed weapon, a dangerous stabbing weapon on or about your person. The way this is charged, that's a felony. It's punishable by up to 5 years imprisonment. And the crime allegedly occurred July 8th of 2024. I was trying to figure this out. The warrant was sworn to by the officer in August 16th of 2024. You got arrested on January 12th of 2025. And you bonded out on January 12th. So I have 1 day there. Then you didn't show up. Adjourned 1 week, you were on behavior center. Then they had a pre-exam conference. On February 18th, they didn't show up. So Judge Patterson issued a bench warrant for your arrest. Then you got arrested again on May 1st. And you've been there ever since. So you got 12 days there. So you have 13 days total jail credit on this charge of carrying concealed weapon, a stabbing instrument. What's the plea offer, Mr. Aubert?
Offers for the defendant to plead to use of methamphetamine and forfeiture of the box cutter and knife that she had.
In addition, the Three Rivers City Attorney, Mr. Reed, granted authority to put their case uh, 24562, disorderly person, as part of the plea agreement. Also dismiss disorderly. All right, so let's break this down, Ms. Wood. The weapon charge is going to be dismissed.
This is Judge
You're
Middleton.
going to plead to use of methamphetamine, which is under the Public Health Code. It's a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. The disorderly person charge from Three Rivers from March of 24 is going to be dismissed. That's got a bunch of no-shows in it too. And as far as I can count, you have 12 days of jail credit. Is anything other than this charge holding you in custody? You don't have a hold from another state or county or anything?
No.
All right, let's go through a couple of other things. I don't have your advice or rights, so let me take a minute and tell you and anybody else that's going to enter a plea that by pleading guilty to this charge, you give up your right to have a trial in front of a judge or jury. Do you understand?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. I say that a lot. Understand?
Yes, sir.
Now, the affidavit in this case states it right out there. Affidavit says the affiant was dispatched a report of a suspicious situation, Constantine Road. Trooper Tracy Smith and a deputy Joseph Chittister went out there. The complainant, Mr. Chittister, said you showed up in his driveway. You were very upset. You're afraid of your husband. There's been a lot of turmoil out there in your neighborhood.
Yeah.
A lot of it from your husband. And they found in your possession a meth pipe, and you said you last smoked it the night before. And you also had some stabbing instrument, box knife, and knife in your bra. So that was the felony charge, not the most compelling, but do you acknowledge that you used methamphetamine before that time?
And before.
All right, that's close enough.
That's not where you keep a box cutter.
You had multiple occasions where you didn't show up. You were in and out of the hospital, but you were like trying to grab smoke with your hands. You then got arrested on May 1st. How did you come to get arrested on May 1st?
The cop showed up to the house because my stepdaughter's boyfriend didn't report to the parole officer, and I was there. So they
came for another purpose, ran you and arrested you.
Yeah, that's her.
Why didn't you show up?
I was in the hospital and I don't have a vehicle. So, and when my mom will come from Indiana a lot of times to take me to appointments, but it's like an hour and a half drive one way for her to get here. And other than that, I don't have any transportation.
Well, they gave you transportation in the back of a police car.
Yes, sir.
that's not a very good excuse because you were out of the hospital weeks before this May 1st date. I'm not sure what to do here. Mr. O'Berry, have any thoughts?
She clearly has a drug problem.
Yes.
I don't know if probation would be beneficial to her to help deal with that.
Mr. Gibson, you have any thoughts?
The defendant said that she's been going to Pivotal and that apparently they were the aftercare after her hospitalization. So she said she is taking steps to be proactive in that regard. And so if I would ask the court to sentence the defendant for credit for time served as far as jail, if the court believes that she needs supervision, then I would ask for a short probation term. Thank you.
We haven't been very successful with our probation. Judge Pattison tried a probation with Ms. Wood back in 2019, which involved testing, and we couldn't get her to test, and the probation was revoked. She doesn't have enough transportation to even get to court or inclination. And then she had another couple of larceny cases in the 2020. And then that disorderly person charge where she missed multiple court dates. So I don't see a probation being successful. Now, this happened way back in July of 2024, and you were distraught and you ran to the neighbor's house and you ended up getting arrested because you were afraid of being assaulted, which I won't argue that point. Then did you just end up back there with him?
They didn't actually arrest me that day.
They took
me to Keystone.
Okay.
And then she just told me that she couldn't tell me that there wouldn't be charges brought up later, and we missed where it was brought up.
All right. We've got a civil infraction also. So are you back with your husband? Who else is there?
My stepbrother.
What's her name?
Destiny.
Oh, and who's the boyfriend that got arrested?
I don't know his last name. His name, Cody. I don't know who. I don't really know him. I don't know his last name. He's still, when my husband came and visited me last night, they Destiny and him.
Is that your Cody?
I'm sorry, what was the last name?
Well, she didn't know it, but he's got picked up, so we'll see. Well, anyway, Miss Wood, Destiny's got issues also. In fact, I thought there was a warrant for her.
I've got an idea. What if we did a cooking show today? We don't have court.
All right, she doesn't have the wherewithal to get to court. She has at least one previous failed probation. I think more than one, but most recent one was 2019. We have a couple of weapons, which were not very compelling. She was fleeing a domestic assault situation. I'll take her at her word. As I said, there's been a lot of turmoil at that house. She failed to appear multiple times, but she was in and out of the hospital for medical problems and mental health problems. If they had tested you on May 1st, would you have tested positive then? for meth? I'm not sure I buy that.
The correct answer is yes.
You obviously knew there was a warrant out for your arrest, and I don't know why you were just waiting to get picked up. When did you last have any involvement with Pivotal or any treatment people?
I had an appointment on May 7th, but I was incarcerated.
When was your last meeting with them prior to that?
Probably, I think we were gone 3 months. He was going to see me, so probably 3 months prior to that, I gotta reschedule an appointment when I get out. But I've been going to Pivotal for quite a long time, like over 14 years. I'll continue to be going there too.
You do have a couple other things that you owe us for, not involving threats or drugs, but involving theft. And I certainly understand, Mr. Aubert, how you came to this plea offer. That's really what the nub of the problem is. But it was last year, it was July of 2024. In between there, the 11 days she got here, she also did some days on the misdemeanor where she continually failed to appear. Same thing. All right. I'm going to order 21 days, credit 12, leaving 9 days to serve. We'll give you a little more time to get detoxed here. 0 fine, $75 crime victims' rights fee, a $50 state minimum fee, and $150 attorney fee. $275 are part of a payment plan, and also other cases. You will get some good time days built into this. So you probably have, I'm guessing, 4 or 5 more days to do, but you continually failed to appear on both cases. One got dismissed outright. I think there is an underlying methamphetamine issue, but this was a year ago. You also had a previous failed probation and a number of unpaid retail fraud fines. So you can go with a court officer. When you get out of jail, I want you to come up here and set up a payment plan to pay this stuff off. All right, you're good to go.
Thank you, sir.
We found a dog named Cora that looks a lot like Chloe, but that's all we know.
All right, do you need a minute, Mr. Truckee? Well, let's sit down and see where we are. I saw that you were doing some difficult sentences. I'm not sure how those 3 sentences got set on your duty day, but that didn't work out so great. And you got a lot of tough cases this week. So let's see what we got before us. right, I
I'm
think
on
we
hold
cleared
with
the
my
decks
auto
of the
shop.
other attorneys,
Getting my car
Mr.
scheduled for
George,
repair, so I can't
Miss
talk.
Ives, Mr. Gibson, Mr. Nossinger. Remaining cases are all been assigned to Mr. Truckee. Eric Austin, do you know what we're doing with him?
I'm going to be having to request a competency evaluation in that case.
Is he in custody?
He's in custody.
Cody Brownridge.
I was able to speak with the complainant, and I believe that's going to be a waiver, but that was the domino that needed to fall before we waived.
All right. Karan Fuller.
Mr. Fuller is here, and there's some objections regarding the traffic stop, so that's going to be left on.
For prelim?
Yeah.
I'll make a record on that one in a minute. Jacob Hamilton.
That's also going to be left on. There is, it's going to be left on for prelim.
All right, there's some bad ones in here. John Heath.
I have not seen Mr. Heath this morning. I know him by face, and I haven't seen him.
All right. Juan James.
I just received several dozen photographs this morning, so I'm going to have to leave that on. I think it may result in a waiver, but I just got some evidence this morning I downloaded while we were sitting in here.
Is Mr. James here?
He's in custody.
All right. And Mr. Brown is in custody. All right, you ladies that are waiting on Cody Brownridge, it appears he's going to waive his preliminary examination. Do you wish to have him zoomed in and do that?
Well, I don't mind running out, and we can just do it on paper.
All right, we'll do it. So he's not going to have a hearing today. He's going to waive his right to have a preliminary examination and have the matter bound over to circuit court. He's also got a parole hold or a probation hold, so he's got issues to deal with his parole also, but there won't be any in-court appearance today. He's simply going to waive his right to the preliminary examination. The matter will be bound over to circuit court and dealt with by Judge Stutzman at a later date. So there won't be anything else going on here this morning. You got a civics lesson. You got to sit here and watch court for 2 hours, but you're free to go on about your business.
Oh, there's still no bond, right?
Correct.
Okay.
Even if he had $1 million, he can't get out because of the parole hold. So,
Just
all right.
making sure. Thank you, Your Honor.
No show. Landrum.
Landrum, I just received a 7 gigabyte evidence link this morning on that one too. So I can't answer that one yet.
We'll leave that on for prelim. There's some bad cases. Brandon Williamson.
He's executed a written waiver.
Is he here?
I let him go after he
All right.
signed the waiver.
Well, let's take care of Mr. Fuller and we'll let him get on his way. Good morning, sir.
Good morning, John.
You got your civics lesson today too.
Yes, sir.
Watching 2 hours of court. All right, this is file number 25760FY. You're Karan Duvar Fuller.
Yes, sir.
You're charged with possession of ammunition by a felon. And that's a new charge. It's a felony punishable by up to 5 years in prison. You're charged as a habitual offender. We're going to leave this on for our preliminary examination next Tuesday at 1 o'clock. Do you understand?
Yes, sir.
Now, you owe me some money in several cases. You got an old case from 23 of what is that? A larceny less than 200. You got some other cases that are already in circuit court, but I'd like you to stop out at the counter about that unpaid stuff. Maybe set up a payment plan to pay it.
Yes, sir, Your Honor.
You're usually, not usually, you're always here when you need to be, and you've paid off a bunch of old stuff. I'd like to get that one taken care of as well. All right, you stop out at the counter, find out about what you owe, and I'll see you next Tuesday at 1 o'clock.
Yes, sir, Your Honor.
All right.
You got my number?
No, sir. No.
All right, don't leave without getting my number.
Yes.
I can give it to you at the court.
That would be May the 20th. 1 p.m. All right, thank you. John Heath from Cassopolis is not here. Would you call a hall for John Heath?
Okay, let me cut from him really quickly. Here's the plan. Schedules are crazy, and court got canceled today without any heads up. We're gonna keep an ear to the ground here, at least till 11, to see if the Zoom hearing that's rumored to be happening today. I'm not sure if that's even confirmed, but it's rumored to be happening. If that's going to be broadcast. If that is, we're going to bring it to you. So we're going to do a little court hopping until then. After that, first of all, if it's not live streamed and there's nothing to bring you from the care and read trial, I'm going to call it and say, let's do a salsa day. Court's been spicy. We want some spicy food to go along with it. I've threatened to make salsa with y'all for a while, and so I'll take you to the store with me, buy all the ingredients for salsa, and then come back and we'll make it up fresh, and I'll test it and tell you how wonderful it is. So we're going to do that today, if nothing else happens, and then we're planning on just coming back with court again tomorrow. So yeah, a shopping stream, which probably gets. I have to be careful. I'm going to switch mics maybe, because last time I got 4 copyright claims on my shopping stream because, InSync was in the background. So yeah. So we're going to get a day off if that's the case, but we are going to wait until we hear for sure what's going to happen on the live stream. So is there another court anybody want to jump to? I know there's a trial happening down here in this guy.
State's exhibit, I believe, 2, the rear view camera outside that shows the Meyer parking lot. Is that correct?
Yes.
And
it's a little bit slow.
When you were asked by the state about certain things, the Pontiac is relatively far off and small on that video, correct?
Sure.
And when the individuals exit the car, is it easy for you to ascertain anything in particular they're doing other than getting out of the car?
This particular trial for background information.
No.
Okay. So it was represented to the court that when they got out of the car, they had their hands in their pockets. Were you able to see that on the video? That immediately when they got out of the car, they had their hands in their pockets?
Charged with robbery.
Right when they exit the vehicle?
Correct.
And
I wouldn't be able to see but using that video.
In Cincinnati.
You can see the hands in the pockets.
Right, but right when they get out of the car?
Understood, no.
No. Do you know where that assertion came from? Have you heard that anywhere in your investigation?
I'm sorry, what assertion?
Were you able to ascertain that they had their hands in their pockets immediately after they got out of the car from anything in your investigation?
I don't believe so.
Okay. So here in this trial was the first time you heard that, right?
I'm unsure. When are you saying this was
before this trial? You hadn't heard that their hands were in their pockets as soon as they got out of the vehicle.
What does they have in their pockets? This is a kidnapping robbery in Cincinnati. 3 defendants on this little trial happening live in Warren County right now. We just sort of popped in on. See what's happening.
I'm going to refer you. Do you mind if I just put it up?
Absolutely.
You've tricked me. There we go. Looking at states 90.
I need to pay my power bill.
If you look at the gentleman in the gray sweatshirt, from the waist up, that's not the only thing being worn, correct?
Oh, he is fully clothed.
Okay, but there appears to be other clothing from the waist up other than the hoodie, right?
Yes.
Okay. You had asked my client in the interview about a change of clothes on the way to the Verizon store?
Yes.
Correct. And with the exception of the clothes that have been presented today, you didn't find any other clothing that you submitted into evidence or that you're offering today or that was significant to your investigation?
There was other clothing when Stratman gets out of the vehicle at Star Wireless.
Okay.
That's what prompted the question. Because we see him in one set of clothing in the Verizon. There's now different clothing that's being worn. So that's what prompted the question.
So, but he had the black hoodie on, correct?
Who's he?
Stratman?
He has a black hoodie on, yes.
Right. And you don't know what was under that at the time of that he was allegedly in the store, correct?
Right.
So, we talked about the idea of my client and his expectations that day. During the interview, he tells you no less than 3 times that he thought he was that he was facilitating driving to a drug deal, correct?
I'm unsure of the number, but he does indicate that he participated in some sort of drug deal.
That he was hired to drive them to that drug deal, correct?
Originally, but then later on in the interview, he indicates when the individuals run out, he knew that there was something different between post-Verizon robbery to going to Star Wireless.
Does he actually, at that time, or does he tell you that when he reached the phone store, Star Wireless, that on the way there, or when they got it, he realized that something else had happened, correct?
Yes.
Okay. He didn't tell you that, hey, when they came back, I realized that they had robbed the Verizon store. He lets you know that when you had that conversation with him, that it is later when he's on the way to the Star Wireless or South that he realizes that something else is going on.
It was my understanding when individuals ran back into his vehicle, I believe he used the term them being, quote, hot as hell before him leaving. That was my understanding of his interview.
So
Hazel, we're doing a little court hopping. We jumped into a little
but in that conversation,
Cincinnati courtroom. Kidnapping,
he indicates
robbery,
that he had no
3
idea
defendants.
what was in the bags or what had happened at that point.
He said that the bag was heavy. He indicates he knew something happened when they got back into the vehicle.
But not what it was.
The defense lawyer doing the questioning right now is
Right,
the
he didn't
defendant for the
specifically
driver
say that.
who was charged
Now,
with the same
when you're
crime.
talking to him and we're discussing the idea of a weapon, you said, hey, something effective, who gives up 40 phones, right?
Sure.
And I'm not talking about mom and pop shops, small liquor stores, but these types of stores in your education training experience as a detective are generally not instructed. They don't instruct their managers or their employees to engage in any heroics, right?
Like specific to Verizon's policies and procedures?
No, just in your education training experience, these type of institutional stores, they don't tell you to take a bullet for the inventory.
Oh, right. Okay. I understand.
When you ask my client about that, who gives up 40 phones without a weapon, did you at that point figure that a weapon had been seen? This is early in your investigation, that a weapon had been seen by the officer or by the employees?
Seen or indicated?
Okay.
At some point, yeah.
While we can have a robbery without a weapon, are you telling the court that a robbery of this type, in your experience, typically goes with a weapon? You said it to my client, who gives up 40 phones without a gun, right?
Sure.
Okay. So you still haven't found a weapon of any kind of connection with this case, right?
Right.
Thinking that there's one out there in the area where people ran or in the vehicle, those were searched because you don't want a gun on the street, right?
Absolutely not.
So if you as an officer are wondering how somebody gets 40 phones without a weapon, why would you think that my client would assume that a robbery was about to happen when he dropped people off if he didn't see a weapon?
I was just using an interview tactic with him to get more information from him, so that's an avenue that I went.
But you just told us a moment ago that you would assume that there'd be a weapon involved in a robbery like this. You said that a moment ago, right?
Sure.
Okay. So under the same logic, why would my client think that something like this, rather than a drug deal, was going down if he didn't see a weapon?
Objection, Your Honor. This is speculation. This is argument.
I'll overrule it. Go ahead if you know the answer.
It's allowed.
Do you mind saying?
Yeah, the question is you indicated to my client that this kind of robbery, and a few moments ago, typically doesn't go down without a weapon, so you assume that there very likely might have been. You've not found a weapon. My client indicated that he didn't have a weapon, and as a result, why would he think, just like everybody else, why would he think a robbery of this nature was going down rather than a drug deal when he didn't see a weapon?
I asked him that question because he was there, and I asked him if he had any knowledge. You know, he was willing to talk to me, so I was just seeing if there's any additional information that he would provide.
Well, we knew he was there.
Sure.
And we've not found a weapon.
Right.
And you wanted to do this investigation to see if he knew what he was getting himself into, right?
Right.
And you've already indicated to the court that a reasonable person would think there's a weapon, so when there is no weapon, he has no reason to believe that something like this is about to go down.
Objection, Your Honor.
I'll withdraw. So,
this must be just for the jury.
you also would have viewed the activity at the Star Wireless from that video, correct?
Yes.
Okay. And when the Pontiac pulls up to the Star Wireless, 3 people get out of the car, correct?
Right.
You've been able to identify the 3 people that get out of the car.
I have.
All right. And at first, who goes into the store?
Rondell goes in first.
Okay. And shortly thereafter, you believe that Mr. Stratman goes into the store.
That's right.
My client sits on the hood of his car, is sitting there. Another car pulls up, and that he seems to be familiar with the people, right?
Right.
And he goes over and talks to them, right?
That's correct.
It is not until he's asked to bring something in that he's even involved at Star Wireless at that point, right?
Other than him driving there and
Yeah.
knowing the location.
At Star Wireless, at that point, he doesn't even initially go in, and it's a while before he is asked to come in. Correct.
Right.
And you saw the apprehension videos from Star Wireless, correct?
I did, yes.
Okay. Who ran?
Mr. Stratman.
Okay. Maybe you can tell me which exhibit, video, etc. it is of my client running.
I never said he did. I said Mr. Stratman.
Right. So there exists you don't have reason to believe that he fled the scene.
I'd argue that when they walk away, they are fleeing the scene, but he's not running.
Okay. He stops outside the store. The officer summons everybody back, and that's it. That's what you saw, right? You were here.
After the foot pursuit with Stratman, when they go back, is that what you're saying?
No, I'm talking about when the officers are stepping out of Star Wireless, and they, hey, you all stop. And the officer actually runs past Mr. Williams.
Sure.
Okay. So you call that fleeing the scene? What Mr. Williams did? In your education training experience, that's what you call fleeing the scene? That he steps out of the store?
I'd say so, yeah.
Okay. Not much of a pursuit, right?
Wow. LNC did an AI-generated recreation of Diddy off transcripts.
Now, I'm not going to ask you what they say, and I understand that it was pre-Mirandized. You said you had a pre-Mirandized conversation with Mr. Stratman.
I did.
And Rondell as well, correct?
That's correct.
All right. I'm not asking you what they said, but was that a substantive conversation, or was it just preliminary?
I'd say it's preliminary.
Okay. Did you receive any information from that conversation? I'm not asking you what it was, but did you receive any significant information from that conversation?
No.
Okay. Did you take any notes from that conversation?
I did.
Did you turn them over to the state, with the exception of anything like they had that they had been Mirandized, and then that was it?
Yeah.
Okay.
This courtroom reminds me of Las Vegas. Don't they have a lot of marble in theirs as well? Like Clark County, I think,
Nothing further.
has a similar build.
Thank you, Mr. Travis. Mr. McKenna?
I hear some chains rattling. Looks like people are in custody. Because there are 3 defendants, each defense lawyer for each individual witness gets to question.
I put it, I'm sorry. Right, no, turn. Now go forward. Second stack. Yeah.
I did the slurping noise, but I was muted. My apologies.
For a photo 75.
Which one are you looking for?
75.
75 was an error on my part. Should be blank on the master list.
Oh, okay.
Good morning.
Morning, sir.
Much of the questions I would have asked have already been asked,
Sure.
but I'm going to ask a few here. Detective Kirby, when you were searching the car, how many masks did you find in the car?
There were 2 masks in the car.
One was in the front seat, correct?
Correct.
And one was under the back passenger seat.
I believe so, yeah.
Do you recall which passenger seat that was under?
I don't, I'm sorry.
Do you recall what the mask in the back passenger seat looked like?
I believe it was black.
All right. And there was also, was there any other masks found in this investigation?
Yes.
And which one was that?
The one in the backwoods backpack that Dejan had.
Okay. Now the one in the backpack, I believe that was marked. The photo was marked States Exhibit 10. That was sent in for DNA analysis, correct?
That's correct.
Okay. Now, was the mask in the front seat sent in for DNA analysis?
It was.
Okay. What about the mask in the back seat?
It was.
That also was?
Yes, sir.
All right. Thank you. No further questions.
Tim, I do have 70, if you want to, I didn't submit it, but I do have 75 if you wanted to have it identify it.
Just one follow-up question.
Yes, sir.
This is, it was not submitted, but this was state's.
That's the mask. Is there no jury? Is this a bench trial?
It's a zoom out at the bottom down there.
Right in front of this. Oh, I see.
Elmos are difficult. As Rob says, lawyers and technology.
Just for the record, do you want to identify that as States 5 or defense?
Oh, I did. Oh, identify this as, you didn't submit it, right?
I did, it doesn't, I mean, the witness can identify it, I just. It
May I
was
approach
not
the
what
witness?
it wasn't what we had a result for, so I didn't.
May I approach the witness, Ron?
Yes.
You just identify that or describe that, please.
Say black Nike mask.
Is that the one that was found in the car?
Yes.
A Nike mask? Just do it? On a ski mask? Not a sponsor.
Zoom here, but there we go.
It's a bench trial. Amber's calling in. Hang on, I'll take it offline for a sec.
And does that say, do you see where it says States Exhibit 75?
I do.
All right, and you've seen that mask?
I have.
All right. I'd ask to submit this, Your Honor.
What do you mean by that?
I'd ask to present it into evidence.
Well, we'll address the admission exhibits after.
Okay, thank you. Thank you.
I don't have an objection to marking it as State 75 and including it.
Okay,
in
that's
there,
fine.
Just for purposes of the record, Judge.
I just wanted to put it in the record. Thank you, Judge.
Yes.
I have no further questions.
All right, Mr. View, any follow-up questions?
Figure out if I actually need to show you the video for this. Do you recall watching the exterior rear door Verizon video? Do you recall reviewing, you've had a chance to review that?
Yes.
And in the first several minutes, shows the white car pull up and sort of, it's in the distance, kind of right on the edge of the tree.
Sure.
And I think when Mr. Walter was testifying, defense counsel, Mr. Travis, had him watch that. And Mr. Travis also was sort of questioning you about whether you could see at the time the individuals get out of the car, you can see 2 individuals get out, stand up, and kind of, and then they begin to come forward into the foreground of the picture, essentially.
Right.
And I think Mr. Travis asked you if you could see whether or not they put their hands in their pockets from the time they got out of the car. And you had indicated you couldn't see that because it's in the distance.
Sure.
From the time you are able, let's say from the time they cross from the Meyer parking lot, cross the road to approach Verizon. Are you able to see their hands in their pockets at that time?
I am.
And both individuals, do they keep their hands in their pockets the entire time?
Yes, sir.
You've had an opportunity to view the other individual cameras from Verizon and also the multi-camera.
That's correct.
Those two individuals, when they cross, there's a side view as they walk down the side of the building before they get to the Sales Quad 2 camera, and they have their hands in their pockets the entire time as they walk down the side of the building.
Yes, sir.
And in fact, those two individuals, Mr. Evans in the gray shirt has his hands in his pockets until you get to the inventory room.
That's right.
So through the time of the threats to the store employees, until they get access to a locked inventory room, he has his hands in his pockets.
He does.
And Mr. Stratman in the black, throughout that time, has that left hand under, right at the waistband of the inside-out black sweatshirt the entire time as they enter the store, down the side, through, until they have access to the locked inventory room.
Yes, sir.
I want to go back, though, to that parking lot. You told us about the face mask that was seized from the backwoods. I believe that states 10, right? And you showed that to the court. It's a single piece mask, right?
Yes, sir.
It has to be pulled on over the head in order to be put on.
That's correct.
And then additionally, we have the mask that was seized from the passenger side of the car. That states 15. And similarly, that also is a single piece mask that has to be pulled on over the head.
That's correct.
We also have the winter gloves, black winter gloves. Those are, I believe, states 11. Right, those are thick fleece. They go about halfway up the
Sure.
arm, almost to the elbow. Right. So those would have to be put on. And then lastly, the rubber gloves that were found on the passenger side floorboard, the noticeable green teal colored gloves. And you put on nylon gloves here while we've been in court, right?
Yes, sir.
Takes 2 hands to put those on.
It does.
Right? Your review of the video, the exterior camera video, when those two individuals get out and they walk towards, do you see at any point either of them put their hands up over their heads as if to put something on their heads?
No, sir.
You see a body motion like that?
I don't.
You see either of them with arms out putting on any gloves?
I do not.
Any point, I mean, you agree with me in all the videos, the green gloves in particular are very noticeable when they get seen.
Absolutely.
Any way that any place that you see those green flash of green color, anything, watching from the car all the way up.
No.
See them do anything like this? Put their hands up to pull a hood up over those masks?
No, sir.
In that video.
Okay, we're getting all set here. Just 1 second. I may be able to retell you what I hear on the Zoom hearing, but I can't broadcast it. I'm just testing. We might be doing what we did in
And at the
the
end
Maya
of
trial.
that exterior video, when Mr. Stratman and Mr. Evans run out the rear, they're carrying in their hands trash bags. They come out the employee exit, right? Not the entrance they went into.
Right.
And they're running, right?
They're running,
At
yes.
speed. And that white car, in your review, that white car actually pulls forward to meet them.
It does.
Right. It doesn't drive away like, oh crap, what's going on here?
Right.
Okay. And then you can see those two individuals get directly into the car.
That's correct.
I think those are all the questions I have on redirect. Thank you.
I thank you, Mr. View. Mr. Aldridge?
Nothing further.
Mr. Travis?
Yes.
In reviewing that video, you can actually see what happens at the car when the two individuals get out of it.
I'm sorry?
You can't see in detail what happens at the car when the two individuals get out of the car, correct?
Right.
So,
We're still doing this
Mr.
also.
Hughes asked you about when they're partially across the parking lot, but you don't know until they're partially away from the car. There's a distance that you really can't ascertain what's going on.
From when they exit, is that what you're asking?
When they exit at the G2,
Sure.
heading towards the horizon, there's a period of time you can't see what they're doing.
Right.
Also, on the, again, it had been implied that they got out of the car with their hands in their pockets. How do you get out of a car with both your hands in the pockets? Do you have any experience with doing that?
No.
Thank you. Nothing.
Mr. McKenna, thank you, Mr. Travis.
Nothing, sir. Thank you.
All right, you can step down at this time. You cannot discuss your testimony with anyone until the trial is over.
Understood, Judge.
Do you want to take the morning break now, Judge?
Yes,
Thank you.
we'll take a break.
All right, well, let's take a break. I'm now configured with two bulky sets of headphones that I'm, where basically I'm going to be able to hear in one ear what's going on in Zoom court in Massachusetts, and the other ear is my own voice. So very stylish. I might just lose the ones that hear my own voice and just trust that you can hear me. But we'll get to that in just a minute. Before court starts, let's jump down here. We haven't seen Judge Simpson forever.
The cases of the people versus Brandon Carter.
I'm good.
Didn't mean to wake you. No.
Didn't mean to wake you.
Long Brown Deputy Chief Public Defender King, on behalf of Mr. Brandon Carter, it has been discovered that Mr. Carter has been lodged at the Monroe County Jail. Oh. But he is unable to make this court date. He'd love to, but.
So he's currently lodged there?
That is my understanding.
Is that also the
He says lodged there like he booked a hotel.
My officer in charge. Okay, so do we know how long he will be there?
No, I do not have that information as of yet, Your Honor.
We don't. All right, well, why don't
I'll
I
do my
this,
best.
then?
I'll do my best. Yeah, if he's in jail, the only thing that gets him out of is a bench warrant. He will have to appear in court at some point. Cases don't get dropped because you're in jail.
I'll find good cause adjourn the preliminary examination. I can set it for the 3rd or the 24th of June, which would 24th. June 24th, 2025.
You don't have
Then this is all messed up. Why? Oh, I can't. You're right.
Correct. You have the 17th in the afternoon.
I have the 17th of
June. Yes, of June, because it's Juneteenth, so it's PMs.
Oh.
So June 17th?
June 17th, 2025 at 12 noon.
Now, would the court consider just a nominal bond in the event if he were to be released, at least he wouldn't drift off into the ether because he wouldn't necessarily have notice of this date?
Drift off into the ether?
Obviously, we will work to rid him, but I don't know. He may get out of Monroe County Jail between now and June 17th.
Any response?
A very, very nominal bond, Your Honor.
I'm buying two new sets of headphones, little earbud. They're dirt cheap ones, but
Like
they're
$10?
so much easier to do this with.
Brown, when have you ever known me to set a $10 bond? I think I did once.
$10 bond.
Still haven't seen that person.
They never showed up.
I'll set bond in both cases at 1,010%.
Thank you, Your Honor.
Thank you. What? Well, are we ready to go on something? Johnson's over there hiding in the corner. He's ready on this?
Yes.
He was over there hiding, but I saw him.
I'm not hiding, I'm just staying out your way.
What? Staying out my way? Why? I am one of the most enjoyable people I know. So why don't we, what we anticipate, 3 witnesses on this one? Are the people ready to go on that?
Still waiting for the Zoom hearing to start.
I don't even expect one witness on the phone.
You expect 1? Okay. And you had 1 or 2?
I have one, but Mr. Gaddy is off today, so he's not here. So.
Is he council approach?
Council approach. It's going off the air here really quickly. Okay, so I'm placing my order. These headphones will arrive tomorrow. They're 2 pairs of headphones, which I love. They're the in-ear ones that are really nice. With tax, $25. I go cheap. So yeah. All right. So if you're not familiar, what our intent here is to follow the exact order of the court. Meaning that the Judge Canoni has ruled that only specific outlets that she grants permission to are allowed to restream directly the court Zoom feed. Because of that, and she may order that the feed today may not be streamed at all. So because of that, we are allowed to observe as members of the public the happenings in a public hearing such as this. As this takes place, I will do my best to recount to you what is happening in court. I have the gift or ability, whatever you might want to call it, to listen and regurgitate verbally, that's a terrible word, almost precisely what I hear shortly thereafter. So I don't do voices very well, but I'll do my best to give you names. So we're going to see if this will work. As long as everything happens correctly, we're sort of in a holding pattern, expecting that we'll see some Zoom activity here in about 6 minutes. And I'm here for it. I haven't done this in a long time. I love it. It's a lot of fun. But when it's all done, I may not be able to tell you what happens, though I can say all the words and tell you everything that happened as it happens. I don't have to. I will faithfully. I won't be able to count size at the same times. Do you know sign language too? I actually learned sign language when I was in 3rd grade. Did a little bit. Now about the only thing I can remember is how to say we're looking for one who acts like a monkey, which was a code we had for a friend of mine. And I know some bad words in ASL and British Sign Language as well. Is it the KR trial? Yes, that's what we're waiting for. We're hearing that there's an 11 o'clock Zoom meeting, Zoom hearing, and we're going to be there for that. I'll be reporting on what I observe. I cannot restream it. I cannot show you the stream. Make sure you have your water ready. Afterwards, will I be muted? Yes, my mic's not even turned on. My video and mic are turned off, so there's no connection that way. Let's see, where's my meeting? Wait, there we go, right here. My 18-month-old granddaughter knows the ASL word for more. Oh my goodness. Parents, I know those of you who have your kids grew up. Let me give you the secret to parenting as a new parent. Teach your child, and by child I mean infant, sign language. teach them more, milk, change. Those 3 words can change your life. They really can. Let's see, what are some other good ones? Eat. I know you could probably teach them play, but that's a tougher one. But baby sign language is a real thing. Real thing. Your child can communicate long before they can form their first like intentional sound. I'm not talking about ooh, gag, go, goo, goo, gaga stuff. I'm talking about way before then. And once the child can communicate and tell you what they want, crying goes way down. Yep, and depending on the child, there may be some other words that they like. Like we had a child who would do this, meaning blanket. They want their blanket. Bernice, I hear your pain. I just scheduled my my Yukon XL, my wife's car, for service. We tried to get the tire replaced off the spare that we've been driving around on since it blew out on us the other week. And the tire, we had to order the tire in. We ordered the tire in. The place tried to take the tire off and said, nope, the lug nuts were put on wrong. They're threaded wrong. And if we try to take them off, it'll break the lug nut, and we won't do that. So now we have to take it to a different shop that can replace the lug nut if it breaks when they took it off. I happen to know that I put it on correctly because I put them on by hand and tighten them all the way down by hand and then tighten them with a wrench. They're not on crooked. Kayla Newell, my nonverbal son has AAC device and he is 12 and we do modified ASL because of his motor skills. It's great. Yep. Good stuff. I do sign language with my husband. It's a bit slang though, says Ree. That counts. That counts. Let's see. Waiting one more minute here for the hearing to open. See when it does. I'm trying to see where I can put it. I need it on camera 3. Actually, I've got camera 3 turned off. There we go. Camera 3 is back on. Virginia, do we get to watch the Zoom? Unfortunately, no. What happens is Zoom has limited entry points, and if we gave out the Zoom feed, it would crash Zoom. And then we'd be hosed. Test 1, 2. Test 1, 2. Nicole Wise, welcome to the gallery. It'll be just a moment when it does start. I've got to be quiet and just make sure all my settings are correct. I do not want to talk even a single word in the court proceeding. So unless they ask me to identify myself, that will be what's happening. Please no. No, I'm going to say what's happening. I will be speaking to you, giving you my play-by-play of observations I make, both audibly and visually, and following the letter of the judge's order. Live is not available at this time. The meeting still has not started. Test 1, 2. Test 1, 2. My audio is good on this side. Okay. Cody, yes, it probably would break the order to do that, so we're not going to do that. We're hoping their information was correct and the meeting starts momentarily. I now can't hear myself, which is... I might have to be able to hear myself to make this work, but I'll see. Hold off on the like button. Wait till this works. If it works, then you can like it. Stacy, I don't believe this is the kids testifying. I don't believe that's happening. I believe this is just motions hearing. Probably will be relatively short, an hour or two. Imagine we're probably going to cover at least one of those motions we read this morning. Bite me. I'm going to get my water right now. Thank you, Rebecca. Appreciate that. Keep my fingers crossed that all our information is correct. Since we joined about 15 minutes ago, it's indicated that there's another meeting that's already going on. So we're waiting for that one to conclude before this one begins. Silly Claus, no court today as far as jury trial and new evidence and testimony, but there might be going over some motions and make some decisions. Mama Rabbit, thanks for gifting a membership. Thank you very much. This is weird because I can't hear myself, and so I can't tell how loud I'm being. Peach, thank you very much. Welcome. I've got audio level meters that I can watch, and I'll try to keep my volume consistent as much as possible. Kaylee, if they found me through the podcast, all I can do is say, I am so sorry. I am so sorry. Probably meant the live streams. The podcast is levity and fun and a little bit of childishness, but always a good time. You call the court and talk with the media representative. That's how you get Zoom info. Letitia Stout, that was an interesting case for sure. Rob is amazing on Lawn Lumber. Keep my fingers crossed that they are going to proceed with this meeting. I mean, it was rumored. We got the info through the court system. But they're now about as late as court normally starts during the day. I'm watching all the different feeds to see as soon as something becomes available, if it does. Oh my. Jonathan Hall tweets out from 7 News. Judge Cannoni is holding a Zoom hearing with attorneys for Karen Reed. Prosecutors are in the courtroom. Attorneys Yannetti and Jackson are appearing remotely. The judge wants this at sidebar. I'm the only reporter in the courtroom, says Jonathan Hall from 7 News. judge wants this at sidebar is a problem. That means we might not be invited in. If we're not invited in, we cannot recount it to you guys. So we can only share what is public. We can't share if the judge orders this at sidebar and orders no reporting on this, then we can't do anything. I've never done a bone induction headset. They're more expensive than the $12 versions I buy. A CW, I currently can't hear anything. If the Zoom is open to the public, even though we're not allowed to re-stream it, we're not allowed to stream it back to you. The technology is all there. That way it would be a breeze to do that. But the judge has ordered that only specific people that she gives permission to are allowed to do that. Because of that, if it's open to the public, I can report what I observe, much like anyone else in the public could watch, listen, and report back on Twitter or YouTube or anything else that they observe. And as long as that happens, I will do that. But if the judge keeps this all at sidebar and doesn't let us in, unfortunately, we won't have any access. Everything hush hush. There are a few things that there were some court orders that should remain sealed, and we approached those topics yesterday when Mr. Brennan made an objection regarding the questions that defense was going to ask of Yuri Buchanan, specifically about information that was received through the federal investigation and the feds getting an investigator's cell phone and data they got from that. That's as much as we know, but a lot of that is probably sealed. Having an investigator's cell phone analyzed by the feds in an investigation, that's crazy. That's crazy. All right, still waiting. Watching Twitter to see what happens, if anything. Well, there we go. The judge just decided to close the courtroom. I was asked to leave, probably due to issues with Reed defense team hearing what was said at sidebar. Closed courtroom means no live Zoom, unfortunately. That's the latest. So no, we don't get to listen. Bummer. If there is another trial that this is an option for, please know I love to do this, and we'd love to do it for a trial if there's one out there. Something's going on. Cheryl with an S says, new sub here in Dedham. Witnessed Hank go to the coffee shop with his 3 bicycle escorts. Mrs. O was there. was here and left. Not too late to cancel your earbuds order. No. I burned through those earbuds. This would be my fourth and fifth set of those specific earbuds, and they're worth every penny. It was a terrible letdown. I'm a little disappointed as well with last-minute closure and the judge kicking reporters out of the courtroom. That means that this Zoom will not be public. We will not be let in. I'm going to stay here unless, in case it at some point does go open. But, man, to be a fly on the wall. Brandy Churchwell, it's got some updates as well. Let's see if we can find hers latest and greatest. Let's see what Jonathan says. Hearing's been going on for 10 minutes now, says Jonathan Hall. Jackson originally appeared off camera because he's dressed in a hoodie. Judge said she didn't care, and he turned his laptop camera on. Jackson in a hoodie. I imagine he had the hood up and the strings pulled tight, like Kanye. There's a possibility sidebar transcripts might be released at once the trial is over and everything comes out. Congratulations, Lisa. Going to be a grandma. That's awesome. Thanks for the news. I cannot picture AJ in anything else but a suit. Well, we are, I do apologize for disappointing you. We are not going to get into the, but he says, I take back what I said. Cancel the super chat. Take it back. We're not going to get into the Zoom hearing. The judge closed this at the last minute and is not letting anybody in. This is a sidebar she's having with the attorneys. There must be some privileged information or some information that's redacted. Judges aren't allowed to do this just on a whim. Generally, there's a presumption of courts being open. I say generally because some states are better at this than others, but generally there is a presumption of courts being open and the public having a right to know what's going on in the proceedings. Oh, I can hear myself. I'm back. So there would have to be some sort of topic that was brought up that would be sensitive in nature, that would possibly go into something the feds had disclosed that should not be coming out to the public, something along those lines. And if that's all that's happening, that would basically be a continuation of a ruling that the judge made yesterday already, and said, I'm not going to allow you to go into that. So unless she's changed her mind, like she slept on this and thought on it and said, never mind, bring Buchanan back, and we're going to let you ask those questions. I don't know exactly what would be being handled here. Maybe she's just going to bend them both over their knee and give them a sound spanking and say, look, you guys, stop leading, stop giving your commentary. This is not courtroom 101. The hearing is over. Yeah. Per Jonathan, the hearing's over. Today's Zoom was to iron out some scheduling issues. I'm going to say BS on that. Because scheduling a hearing and closing it to the public to iron out scheduling issues, unless it was something that, if it was scheduling issues of a witness who's been threatened or something like that, I can see that. I can see you don't want to let people know when they're going to be there because they're worried for their safety and going to a known location. Possibly. But just like, hey, how long do you think you're going to take? That should be public. So So hearing's over. We're gonna save the Zoom info for next time. And here's what we're gonna do. I've threatened to do this for a long time. I'm going to take you shopping with me, and I realize this is a bit of a deviation from a true crime LawTube adjacent channel, but we've had a lot of spice in this case. It's been hot. It's been hot, and I am going to teach you guys how to make hot salsa. I'm going to make it fresh. I'm going to walk you through all the steps and make it here in the kitchen. Then I'm going to taste it and tell you how good it is. That's how it's going to go. I'm going to make about a gallon of it, which is single serving size. Regret comes the next day. But we're going to go shopping. I'm probably going to get copyright stricken. So I'll see if I can figure out some mics that will not pick up the music so much while we're in the store. I get to ride in the cart, says Shaky Ground. Salsa and tacos. No, just salsa and chips is all we're going to do. Well, I need to put my bra on. Cindy, based on what we heard this morning, depends what else you want to put in there. So if you need to bring tools and knives and things like that, like we heard in court this morning, then yes, probably. I don't recommend doing that for the store. Shotgun, says Purple Coconut. I'll put my flip-flops on. What time are you going to start the salsa? Carol, we're going to do first a live stream from the phone, where we're going to drive to probably Lowe's Foods, not Lowe's the hardware store. Please don't get this confused. If you're trying to follow along at home, and I say we're headed to Lowe's to get everything we need for salsa, we will not be buying lumber. We will not be buying appliances. We're just, Lowe's Foods is a completely different store, and we're going to try to do that. Murder Walmart, if needed, we'll go to Murder Walmart. But first I'm going to be looking for some jalapenos, some good, I don't know, maybe some garden salsas. What do you want, Serrantos? Let's put a habanero or two in there. But we look for a few peppers. That's a good mix. We need some fresh limes. We need the cilantro. We need. I've got the salt. I think I got that covered. Garlic. Definitely need to have fresh garlic. Cloves. I've got a garlic peeler now. Thank you very much. I'm going to use that. Onion. I'm going to go white onion this time. Large white onion. Probably use at least half of it. Maybe a little more. Just depends. Then we can do a couple other things. If you're willing to branch out a bit, we can say, have you ever tried diced radish? Diced radish gives an amazing crunch, and it still has that bite to it. That's good. Also, on the other side, if we need to cool it down a bit, maybe if we can find some avocados that are just right, not too firm, not too soft, we could dice some avocados. That actually takes the heat back a little bit. If we accidentally put too much habaneros in, that can dial it back a bit with the avocados. So, is anyone writing this down? No, it's always in my head. Cilantro, definitely. Cilantro is a for sure. Hearts of palm in my salsa. Never tried that one. Is the headlight being delivered today? The headlight should come today, tomorrow-ish. I know it's been shipped. I have to track it. I also have one of those big Jackery battery packs coming that can run my Starlink for like 30 hours. I have that coming. The headphones come tomorrow. I don't know what else I ordered. Corn. Not going to do corn in this one. No corn. Teach us how to squeeze for ripeness. Yes, in the store on ones I don't buy. I will do that. I'll teach you how to squeeze an avocado. This is important. You grip it by the husk. No, you grab the avocado as you would, say, like a baseball or a softball. And got a call coming in. Hang on. Hello? Trying to hear you. Hello? Did they hang up? They hung up. Tried to answer it. Grab the avocado, grip it so you have a good firm grip, and you want to take whichever finger you're most comfortable with performing like gradually increased pressure, but not sudden. I mean, you're not trying to do Hulk smash, right? You're not looking to have avocado oozing between your fingertips. You want to just grip it firmly, and then with the finger you can, like I use my thumb, you can apply increasing pressure, firm pressure, but not too much, gradually. Because if the avocado is too ripe, usually it's going to be very dark, like a black type skin. If it's too ripe, you're going to just thumb will go right through the peel even. That's way too ripe. It should be thrown away. It's no good at this point. You can't even make guac out of that. If it is like rock hard, solid, like this just came out of the freezer, it's not ripe enough. What you want is right when you squeeze, there's just the tiniest bit of give, just like a give. It's good. Take that one. Don't even put it down. Just take it from your hand, put it in the bag. You want that one. Don't look for another one that's similar. It's like they're all different. Grab the one, buy the one you squeezed. And no mango. Amber says check my texts. Where did you text? Checked your texts. Interesting. All right, we'll stay on that, Amber. So we'll see what happens. You want the avocado to giggle like it tickled me Elmo? No wireless headphones, sorry. I do wired. Don't like the delay. Avocado ripeness truly is a feeling. It is. Let's see. So bell peppers are good, but not for flavor. You add bell peppers for color, or color, for those of you who say it wrong, for color and for a little bit of texture. I don't add the seeds for bell peppers because that really doesn't add much. If you want to add seeds, you want to do it on the hotter ones where it's going to be a jalapeno or a habanero if you're really brave. So what I learned today, people put weird stuff in their salsa. I need some not so hot. We'll show you how to do that. Take the stem off avocado to check for ripeness. I don't do that. Maybe I should. Red bell peppers, I do green. And the reason why I do green is because I do a lot of Roma tomatoes. And Roma tomatoes is where you're going to get the red color in your salsa. A ton of them. So we'll probably be buying, I don't know, in the range of a dozen to 20 Roma tomatoes. Serrano chilies are good. Bell peppers just for the texture. Serrano or jalapeno, not bell. I would do. Bell has no heat. You're adding the bell pepper for the crunch that it provides because they're wonderful as far as a crisp pepper. You need a list. It's all in my head. In his head is why it takes 4 hours to shop. When are we going? Do you have time to do your hair? You do. You have time to do your hair. I'll drive around, pick everyone up in our car that needs to be serviced. I'm growing all this stuff this year. I make my own salsa in Canada for the year for me and to give to my adult kids. That's awesome. Is Mrs. Ari going? If I can talk her into it, because today's our 25th anniversary. We're married 25 years today. So I'd like to spend as much time as possible with Mrs. Ari. So why not go on a field trip and make her salsa, right? Do you have an Aldi's store nearby? They have good fresh produce. We might go to Aldi's as well. We have an Aldi's, we have a Lidl, we have Walmart, we have a Murder Walmart, Sam's Club, Lowe's Foods, and Food Lion and Piggly Wiggly. Those are our options as far as the stores go. So, is there anything that isn't in the fruit and veggie aisle? This is a fresh garden salsa. So, let's see. The only thing we would add that isn't in the... No, it's all fresh. It's all fresh. Nothing from a can. As soon as you add something from a can, you lose texture and you lose flavor. So we're not going to do that. We'll be stopping at AutoZone this time. I hope not, because it's raining outside. And we don't need to do that. Greeners, thank you very much. This grocery date funded by Greeners. Greeners, thank you very much. Appreciate that. Rose with Thorns says, happy anniversary. Happy anniversary to you. Memberversary for 10 months. Rose with Thorns, thank you very much. You aren't making Lori's enchiladas. That was last time. This is going to be salsa. So here's what's going to happen. We're going to do the shopping trip. Hopefully, I can get Mrs. Ray to come with me. That would be really good. And then we'll have a break because between the shopping and when we make it, I need to set up the studio in there. And that takes like an hour. I know it's a pain in the butt, but it takes an hour to get everything set up and put out there and plugged in and cameras and lights, camera, action. You need dill pickles in your salsa? I've never tried that. Don't forget a container or jug to store it in. The thing is, it doesn't keep very long at my house. We will eat a gallon of salsa within 24 hours. It's gone. He's gone. He's gone. The Walmart near their house is scary. Yes, it is. It has 2 police mobile crime watch cameras in the parking lot at all times. Children have been abducted from that store. Just let that sink in. To get to the murder Walmart, you drive through the main drag in Greenville. You turn right on Greenville Boulevard, and you pass all the nice restaurants, the Golden Corrals and everything, KFC, and then you drive past Hooters, which I think is shut down now because, even they couldn't stay in business in this area, and the smoke shops, and, all the gas station where no one goes to buy gas because you just don't, you won't make it out, that place. Then you take a left on, you guessed it, Hooker Road. You turn a left on Hooker Road, and that will take you down to the murder Walmart, which we shop at occasionally because they have the best selection. Happy anniversary to you, Mrs. R.A. My husband and I got married in Vegas on tax day 2000. That's 25 years for us on April 17th. That is awesome. That is awesome. Greenville used to be so peaceful. Haven't been in 20 years. It still is peaceful. It's just scary. It's quiet. Yes, so we're going to go down. Maybe we'll go down there. If Mrs. R.A. is coming, we will not go there. She will not let me go there. You can't make this stuff up. Yeah, whoever chose this was great. So Aria's not going to hear anything. Virginia, unfortunately, no. The judge at the last minute sealed the meeting, kicked the media out of the courtroom. So this is all we got to see. So there's another meeting and it going on, and this one hasn't started. So that was it. We never got in. Wonder what they sell on Hooker Road. Good question. All right. Nice flower. Why, thank you. It's a Zoom flower. All right, that's the plan. Any problems, any questions, any objections? Give me a minute. What I'm going to do is I'm going to work on a wireless mic. Because I can, on a wireless mic, especially the Rode mic, I can turn down the gain so that it will pick up my voice just fine, but not necessarily the music in the store. And if I can get away with no copyright claims or copyright strikes today, that would be great. That would be just wonderful. Hooker Road is where all the towing companies are. I wish. Nope, no towing companies. Although you can get hooked up there, I hear. Found Old Bay Goldfish, says Kayla Newell. That is awesome. I don't think Ayden City has Hooker Road, does it? We might. I'm talking about Greenville, though. How did you get Mrs. R.A. to stay in the house with the snake in the attic? Virginia, we didn't tell her about it. Donna, thank you very much. Is there a store with no music? Most of them have music because it encourages people to buy. It makes them pumped up. Oh, Virginia. Look what you've done. Hey, Mrs. R.A., do you want to leave the house and come with me and go shopping if we don't go to the murder Walmart? Can I be in charge of your thumbnail for this next stream? I've got some images, says Josh. I don't think it lets me do thumbnails for a vertical live. No music at Aldi. They're too cheap, says Eddie. Aldi doesn't like us. Aldi and Lidl, which I believe are basically the the same store, just direct competitors. Thought it was on the deck. It was climbing up. It was climbing up the windows around the door to get to the roof, because it's a bird-eating snake, and that's where birds fly. It's true. If Miss Zari finds out about the snake today and you didn't tell her, it may not be the best 25th. Just saying, well, she knows now because she's in chat. Virginia says it's now in the attic. No. All right. Thanks for the kind words, y'all. Let's get ready and let's do our salsa thing. Remember, we do not have a podcast this week. And instead of a podcast, I have another thing that I'm helping a friend with on Thursday night. So there will be no podcast. This is in place of the podcast. We're just going to do it in the middle of the day. So with that said, and with all your blessing, we're going to go ahead and wrap up this portion of the show, which turned into a dud a little bit because the judge, first of all, somebody got sick. We think it was Karen Reed. We've got some sources that on the inside that say it was her. She's not feeling well. The judge then orders a Zoom hearing, which we get access to, and then she closes the Zoom hearing, so we don't get to hear anything. So a bit of a dud. So hopefully we can fix that by having a great little shopping trip. This is all right. We get free salsa. Well, free. The company pays for it, and it's a tax write-off. It's a good deal. It's a good deal. We'll see if she'll go with me. Cross my fingers. She's made no promises yet. Thank you very much. Thank you mostly to Mrs. R.A. for her patience. 25 years. Thank you, Mrs. R.A. Love of my life. Thank you for being patient. Why can't they just say Karen Reed is sick? Probably some HIPAA violation or something. Usually that applies to doctors, though. Oh, she'll go, says Linda Lou. Well, you putting that pressure on her. We'll see if she does. All right, what time is shopping? Here soon. I've got to check with her schedule. Click the subscribe button on the page. There's a bug on the wall. Right there. It must be the rain. It's pouring rain outside, and now it's coming inside. It's on the wall. It's 9 feet tall. I can see the raid. Okay, I know what I have to do, guys. I know what I have to do. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again, and shortly, as long as this bug doesn't kill me. You guys have a good one. We'll see you on the shopping trip. Wish me luck. Grr. I got it. I'm not sure if you guys saw it fall, but you might have heard it hit the ground. It's dead. We can go now. All right. It smells like lavender in here now. It smells beautiful. Actually, that's lemon. It smells good. You guys have a good one. Let me get this set up. Okay. See you on the shopping trip. Bye-bye.